All right, I'd like to call to order the Town of East Troy Planning Commission, our decision-making meeting for the month of March. Like the record to show that all the commissioners are present with the exception of Commissioner DeGrave, and Commissioner Russell is sitting in for him. This is our decision-making meeting, so tonight we will not take any input from the audience. We are going to have a small discussion amongst commissioners, and we're going to make our decisions tonight. First item on the agenda is to review and approve the Plan Commission meeting minutes from February 5th as well as March 5th. I know some people had already given Jen some corrections. Is there anything else, any other concerns with the minutes?
I looked at the revisions and everything.
Right. Joe, I noticed you had one more or something.
Yeah, it was just on the, what is that, third paragraph down after the red cup. CUP there, on that next, it says discussion making meeting. I thought that should be decision.
Sure.
That's the rest of it she found, so other than that, I think everything looks good.
All right, I take a motion then.
Make a motion to approve the planning commission meeting minutes for February 19th and February 5th with the amended changes.
We have a motion to approve. Do we have a second?
I'll second.
All those in favor?
Aye.
Opposed? Motion carries. Next item on the agenda is conditional use, N8828 Stringers Bridge Road, East Troy, parcel number PET 1800006A, Westerard Cottage Industries. Commissioner, thank you, Joe. Commissioner Joe Johnner has recused himself from making the decision. Obviously, there's been a bunch of discussion. We pushed this off for 30 days, so here we are. I guess I would take any discussion or points or concerns.
Well, we tabled it for 30 days to see if we get any more information that the applicant could provide around the letter with regard to requiring an additional variance for the structure on the place.
Mm-hmm.
Did we get any correspondence on there on that?
I have not seen anything.
That's the October 23rd.
I have a copy of what I have if you want.
Okay, sure.
I've got some points I'd like to, when the time comes.
Certainly.
And I guess, and to me, the one, I don't recall really resolving the issue around the split zoning, the C2, C4, and the appurtenant,
Can you cross over?
So, and it seemed really, we got a lot of conflicting reports. I think we had some lawyers, multiple attorneys in the room, over the course of this thing, and then the town attorney chimed in, Michael Cotter chimed in. It's really not clear. So I think for me, as far as that issue goes, I kind of if we're not getting clear guidance from the county and ultimately they enforce those sort of things, I think we just, to me, we leave that to the county.
Sure.
Yeah, and I think that, that horse is out of the barn. It's been rezoned by the county and approved by the town board, so, you know, talking about that rezone that's already passed, you know, we're not an appeals board.
Agreed.
So I think that is off the table, that's my opinion.
Sure. I know Commissioner Russell did a bunch of research. I don't mean to cut you off. If
Oh,
you-
no, that's quite all right.
I'm just thinking maybe if we let him show his findings, it might answer some of the questions we might have.
Sure.
Okay.
Yeah, I just want to recap some things I've determined and just some things we heard about. And as you said, Joe, it was a month ago, but, you know, if you recall, at the February 5th meeting, it was explained by Town Chairman Bob Miller, and it's also documented in the county's record, that in 2005, the applicant illegally excavated the hillside of this parcel without a permit, which the applicant now represents can act as the parking lot for his proposed marina. However, at the time of the illegal land disturbance performed by the applicant, a settlement agreement was made between the applicant, the town, and the county, that in return for not making the applicant restore the land to its previous condition, which would have been extremely difficult and expensive, the applicant agreed not to use the parcel in the future for parking or storage of boats or the placement of any structures or buildings. Now, that's a fact. I mean, how that enters into our decision-making, or whether we can use that as a reason, you know, to deny.
So you mentioned it's a fact, but where was that documented?
It's in the county's, it's in the permit that he was issued to restore restore the property. And we passed out copies of that at the last, Jen made copies of that at the last meeting. I have a copy I can get you to. Let me keep going. It was also pointed out to us by the attorney representing the Lake Beulah Management District, who was here at that meeting, as memorialized in his letter dated February 4th, the day before the meeting, that it was determined by the county in 2012 and upheld by the Wisconsin Court of Appeals in 2015 that the applicant had been illegally operating a commercial for-profit marina. And by the applicant's own admission, he continues to operate an illegal commercial for-profit marina. Now, whether that can be used as a reason for us to decide for or against, I'm not sure of that, but it affects my thinking. The other thing I think is significant, in the February 5th meeting, the applicant himself acknowledged that in the past, he has and he intends in the future to launch and retrieve boats with the use of a fork truck or lull or telehandler, whatever you want to call it, within the area designated as C4 by the county, and the area designated as an area of natural resource special interest by the Wisconsin DNR. This type of use of the land isn't allowed under either of those designations. Specifically, C4 district, which we know stands for Shoreland Wetland District, and I'm reading right from the ordinance, is created to maintain safe and healthful conditions, to prevent water pollution, to protect fish spawning grounds and wildlife habitat. The primary purpose of this district is to preserve, protect, and enhance the lakes, streams, and wetland areas in Walworth County in a manner that minimizes adverse impacts upon the wetland. the proper regulation of those areas will serve to maintain and improve water quality, both ground and surface, prevent flood damage, protect wildlife habitat, prohibit the location of structures on soils which are generally not suitable for such, protect natural watersheds, preserve shore cover, preserve natural beauty, and protect the water-based recreational resources of the county. So in my view, by the definition of C4, it explains why a marina, it isn't either a permitted use or a conditional use within C4. I think we all know that, right? And the county's chosen to say that part of the land is C4 and part of the land is C2. But the C4 land just can't, not even a conditional use. And I know this is a conditional use application, but it's not even allowed as a conditional use.
So on that, that's the way I initially interpreted it too, and that very well may be, but that's not the direction we got from Michael Cotter at Land Use Resource Management. So I do think that in the attorneys that came before us, the town attorneys had different opinions. So that's where I think, in terms of the C2, C4, to me, that's off the table. We should just leave it to the county. Because it's one way or another, it's probably going to be litigation.
But Cotter even mentioned, the one case that he mentioned never went to court. The case that he mentioned in Whitewater never actually went to court. So that's why, a little, I understand, which even muddies it probably more. So,
I think, to me, it's important to bring up and discuss, but ultimately, it's county ordinance. And I think we have to rely on the expertise, the legal expertise, and the professional expertise of the county zoning agency. It's been murky. So when it's murky, I think we should err on the side of the property owner there. I maybe don't agree with it, but that's where I stand.
Yeah. Well, I do disagree. I think they've rezoned the land to C4 and C2, so we have no choice but to use the book on what is allowable and what's a conditional use allowable within the book under C4 and C2. In C4, it clearly said, because there is no...
It may say that in the county zoning, but Michael Cotter in the Land Use and Resource Management Department failed to defend that properly and failed to take that to court. So I don't have, we have, there's just no, and what he's saying is that it's okay.
Who's saying
That was in Michael Cotter's letter. There was
I disagree. All they did was change the zoning to C2. They have not ruled on the applicant's
yes,
conditional use.
but Michael Cotter,
failed to enforce it.
Michael Cotter did mention in his response to Jim Mills that there was a case where there was that strip of C4 and somebody sued to cross over C4 into their C2, but it never went to litigation. So again, that's still very gray.
Right, well, Mills said it's never, Mills followed up with an email to all of us and said it was not ruled on and there is no precedent. So,
And that's where, as murky as that is, that's where I give some, to me, I give some leeway to the property owner.
I got one more thing.
Yeah, continue on.
So, the other thing that's important is, I'm sorry, give me 1 second, I lost my train of thought. Okay, here we go. So I already gave my dissertation on the C4. In my view, it's not allowed either as a permitted use or a conditional use. The other interesting thing is under Walworth County C2, whereas a marina is an allowed conditional use within C2, The ordinance specifically says that a marina development within C2 is subject to the criteria for conventional design, which requires a minimum lot area of 5 acres and a minimum lot width of 300 feet. The applicant's parcel is less than a half of an acre and is only 119 feet at its widest point and tapers to 0 feet. It's basically a triangle. So it has an effective average width of approximately 60 feet. Again, just to make it clear, the ordinance says you have to have a minimum lot area of 5 acres. The applicant's lot is less than a half an acre. That's only 10% of what is required. And the minimum lot width required is 300 feet. The applicant's parcel has an average width of 60 feet, which is only 20% of the required minimum width. So the applicant's parcel is much, much smaller than what the ordinance requires for a marina. I don't know if anybody's researched.
I think we brought up a lot of this during the zoning discussion, and that's a big part of the reason why we motioned to effectively deny the zoning
Right.
petition. I don't disagree with any of that, but now that.
Oh, but hold on, it wasn't zoned C2 at the time, and this has to do with the conditional
Right,
use
so
for
now that it
marina.
is C2.
It's a substandard C2 lot, right?
Now that it is C2, he has to follow the
Okay.
criteria in the book. So just because it's C2 doesn't mean you're automatically granted a conditional use.
Right, yeah, absolutely. But the lot size requirements and things, they're derived from that zoning code, right, of C2. Those match, that matches the definition of a C2, a standard C2 parcel.
What does? The 5 acres?
So-
Yeah, right. But you could have a big area of land designated as C2, and you could have portions of it that are smaller than the 5 acres, and therefore, like you said, it's a substandard lot, can't be developed. You know, there's substandard lots on other parts of the lake and other lakes. You can't develop them.
Well, in those cases, oftentimes we grant variances.
Well, that's a different application.
Because it becomes a hardship, because you have a substandard lot near these lakes where these lots were defined years and years ago, cottages, became homes.
But that would be I agree, but that would be a variance process. He's come to us with a conditional use permit, a request for a conditional use permit. So let me keep going. So that was my second point. My third point is, it's also important to know that the State of Wisconsin Administrative Code, Chapter NR 103, NR is natural resource. So again, Wisconsin Administrative Code, Chapter NR 103, requires for the purpose of environmental protection that the DNR review and approve any project within an area of natural resource special interest. And the applicant has not provided us with evidence that they've obtained approval from the DNR. So those are my kind of 3 points.
Sure. Any other discussion or response, or?
Well, to me, I think the crux of the whole thing for me is this special area. You know, if there's there was no special area, this would be not a big deal.
Mhm.
We would go for it immediately. It's all the murkiness around going back and forth between the C4, which is, and a C2, and that C2 is kind of a spot zoning, which is not illegal. But what I read about it and when I talked to CPAC about it is that it causes problems. It causes this murkiness. So that's what I have a hard time wrapping my arms around, is how is this area going to be protected? We heard from Robert Nota, N-A-U-T-A, from RGN Environmental Services, He's also associated with Lake Eagleton Management. Also, Jennifer Thorach provided a lot of information about how, in her expert opinion and in Robert's expert opinion, that there's the possibility that a marina could impact the lake negatively. That's my concern.
Which is exactly why the DNR, which is exactly why he's supposed to go get approvals from the DNR before he even asks us for this.
So here's where how I kind of look at this. It's a complicated application for all the reasons stated. And anytime someone wants to do something near a lake and you're in this, you're gonna have to deal with the DNR, state statutes, county ordinances, plan commission, town board, town ordinances, and matters much simpler than this go back and forth between the county all the time. Property owners do have to start somewhere. Oftentimes, and this comes up with extraterritorial matters, oftentimes property owners will go to the extraterritorial jurisdiction first, get an approval there, and that approval is pending approvals by all these other government entities. You do have to start somewhere first. I don't think it's our place to say where the applicant must start. So I think with regard to the DNR review of a sensitive area that's absolutely required, that could be a condition. And I think that's easily resolved by, if we were to act on this, that's a condition. Now, I think I've heard, we've had so many meetings on this, and I think it comes down to the intensity and the nature of the use of the property. There's concerns around, traffic and use of that roadway with the equipment, and there was concerns about the dated wetland delineation survey. The county brought up concern around the non-conforming structure. So what I did, and I asked Joel to pass these down to you, but I print, just to get this on the table, to try to frame the discussion. I think if we're to try to balance the needs of the community and the rights of the property owner, right? I mean, we have a property owner that has a right to use this C2, C4 property. Now, it's non-conforming, it has grandfathered piers that are used currently grandfathered for personal use. It went to court, went to the appellate court around, the use of trying to get this grandfathered use of a marina in place, and the appellate court and the circuit court ruled against the applicant. So as of right now, he cannot operate a commercial marina. That's pretty clear to me. So to balance the needs of the community and the rights of the property owner, I tried to frame some conditions that really bring the property into compliance it shouldn't have enough copies for you. But to bring it into compliance with a C2 zoning, and I'm setting aside the split zoning issue because frankly that's beyond me. So I'll just highlight these and then maybe you can have some discussion. So reduction of piers. Property owners shall reduce the number of piers and slips on the lakefront so as not to exceed the maximum number of piers and slips allowed by Walworth County, Town of East Troy, and current DNR regulations. All remaining piers and slips must comply with all current regulations of those entities, and do that within 12 months of approval of the permit, and verification of compliance should be submitted to the Town of East Troy Planning Commission prior to any commercial use of the property. So I think that, to me, and I don't know if that means 1 pier or 2 piers. There was a lot of discussion around cord length measurements and things. But if the property was brought into current compliance with the number of piers and how those piers are configured, maybe it's 1 or 2 piers, that brings down that intensity of the use down to something comparable to a residential property, despite it being used for commercial use. 1 or 2 piers, you can only use that so much, right? Next one, there's a lot of discussion around pier registrations and town ordinance. Just bring it up to compliance with the current code in terms of pier registrations. Removal of non-conforming structure. I added this because to me, this would be a conditional commercial use of a property, but there's also, the applicant currently wants to use some piers for personal use, continue to use this existing structure for personal use. Well, now we have an accessory structure without a principal structure on a C2 property. So to me, that doesn't make any sense. Bring it into compliance, remove the structure. Condition it also upon receiving an updated wetland delineation survey, also detailing out the removal of the structure and the new configuration of the piers. Last but not least, prohibition on equipment for boat movement. So property owners shall be prohibited from using any mechanical equipment, including but not limited to telehandlers, forklifts, or similar machinery to retrieve boats from the lake or place boats into the lake from the road or any portion of the property. I think that's an important one. There were residents that brought pictures, evidence of a telehandler placed on or near Stringer's Bridge Road on the bridge, moving boats into and out of the lake. If I had a loved one that had a 911 call to East Troy, the East Troy Fire Department, and the fire department had to respond to that residence to go, provide medical care, and they came upon a telehandler blocking the road and had to deal with that telehandler dropping a boat into the lake or moving the boat or backing up. I think that's risk to health, risk to life. That's dangerous, and I don't think we can allow that. I think it'd be negligent to allow any, continued commercial use of heavy machinery on that road. I don't think it would be appropriate to use heavy machinery into or out of the C4 area, that wetland area. I make a distinction between that and foot traffic into, coming into and out of a pier or two. I think we could also add a DNR review, as you stated, John, as a conditional use. If we wanted to move
Who's
forward.
gonna enforce all of this?
Amen.
Well, here, let me.
Okay, so let me answer that. I agree. So that's where reduction of the piers, the pier registration, removal of non-conforming structure, that must be done before commercial.
Ben, you could put 1,000 conditions on this. The applicant has proven that he doesn't follow the law and he doesn't follow through on agreements. So all you're doing is giving him an opportunity to take advantage of the situation. And I think that's where you were also.
How is that different? How is that any different than where we stand right now today?
Because we have enough justification
No.
to deny this application.
No, you misunderstood. How do we enforce the lack of commercial use of that property today? And how does approving a conditional use with conditions change that to the detriment to the community? I don't think it does at all. In fact, no. Read my notes. The applicant must comply, remove the piers, remove that structure within 12 months, register those piers, bring it into compliance. If it doesn't happen, the conditional use is invalid, and we're right back to where we were.
Well, let's stop it now.
Yeah, we should just stop it now. Right.
I mean, why go
Have
through
we?
the
It's
torturous?
being used commercially now.
But
The applicant-
I'm okay leaving the status quo. I mean, he's operating, it's up to the county to enforce an illegal operation. Why give him the opportunity to do more illegal stuff?
And that's fair. I mean, I thought that it'd be negligent to approve it without conditions. I thought if we wanted to bring something to the town board with conditions, we might frame it in this.
I think that's good, yeah. If we were to grant the conditional use permit, yes, we'd have to have the minimum of these restrictions.
And I think, given the history of this property, and given that I thought we did a lot of due diligence around the zoning issue, and then the town board disagreed, right?
Well, I have a point of view on that, too.
Okay, and so I think we're serving the town and the town board by, what I would suggest is we move to approve with conditions, and we can, and vote and decide how you like. And at least that's on the record, and that can be presented to the town, to the county. And that's how I think we could move forward.
I think the advantage to doing that is, in reality, we know that the town is going to, if we deny, the town board's going to approve, and the county's.
Well, I don't know that they can, because I was gonna suggest that the plan commission issue a memo to the town board reminding them that if the town board considers overruling our decision and recommendation, according to Act 67, they need to indicate clearly any mistakes the plan commission may have made in our decision. They can't make a decision based on a personal view, like they consider themselves to be pro-business, or they're personally sympathetic to the applicant. If they do overrule our decision without giving substantial evidence, they're gonna put the town at risk for expensive legal action, they're gonna put themselves personally at risk for conflict of interest. Now, if we wanna put a motion forward on approving the conditional use with the list of conditions, just so it can be, I'm not gonna approve it, but I'm happy to approve a motion that has a list of conditions on it, but I'll consider it, but
So, yeah, so, just for the record, if I may make a motion,
yeah. And see, but my problem with that is we're giving the town we're giving them an opportunity, well, we're not gonna approve it. Okay, I hear you, okay. Make your motion.
we're not elected officials, we're advisory to the township.
Right.
To
And,
make a recommendation.
Yep,
okay. So, I motion we approve the conditional use request for parcel PET 1800006A with the conditions that I outlined, and I have a printed copy I could provide to Jen for the record. So, reduction of the piers, requirement of pier registration, removal of the non-conforming structure, updated wetland delineation and survey, and prohibition of equipment for boat
can
moving.
we add approval from the DNR?
And a DNR review.
Yeah. So approval, not just a review.
And a DNR review and approval.
Yeah.
We have,
A timeline for this to start, I know we have an ending time, but a timeline for it has to be initiated.
I have it written in so I can, should I read all of them?
I don't think that's necessary. We have a motion to approve the conditional use based on the conditions that Commissioner Smith delineated. Do we have a second?
I'll second.
All those in favor of approval, say aye.
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 Opposed? Aye.
Aye.
Motion fails. So then,
I'm willing to make a motion.
I would take a motion from Commissioner Russell.
Okay, from what I understand about ruling on a conditional use permit, and in light of Act 67, our determination must be based on substantial evidence as opposed to personal preference or speculation. We must explicitly describe the substantial evidence. Therefore, I would like to make a motion that the Plan Commission deny this application for a conditional use permit based on the following 3 reasons. Reason 1, under Walworth County Shoreline Zoning Ordinance, within a C4 shoreline wetland district, a marina is not a permitted use, nor is it an allowed conditional use. And per section 74-179, C4, paragraph 3, a marina is a prohibited use within C4. That's reason 1.
Before we go too much further with this, wouldn't each of us have to provide the reason for our vote? I mean, I feel uncomfortable with accepting somebody else's total rationalization about why.
But I can show you in the book where all this.
I understand
This
that.
isn't my
I understand
opinion.
that.
Yeah.
But there's more to it than that.
So I understand that, but we've never had a motion where each of us add it to the motion. So this is John's motion, and it's just gonna sink or swim on its own validity. Continue.
Okay, reason 2, under Walworth County Shoreline zoning ordinance, whereas marina is an allowed conditional use within C2, a marina development within C2 is subject to the criteria for conventional design, which requires a minimum lot area of 5 acres and a minimum lot width of 300 feet. The applicant's parcel is significantly smaller than the required minimum area and is significantly narrower than the required minimum width. Reason 3, the Wisconsin Administrative Code, Chapter NR, Administrative Code, Chapter NR 103, requires for the purpose of environmental protection that the DNR review and approve any project within an area of natural resource special interest. The applicant has not provided us with evidence that they've obtained such approval.
All right, we have a motion to deny the conditional use. Do I have a second?
I'll second.
All those in favor of denial, say aye. Aye.
Aye.
All those opposed to denial?
Aye.
All right, the denial is successful, and that's all we have on that. Is there any other business amongst commissioners?
Well, I'd like to get consensus on writing this memo to the town board, make them understand the responsibility they have to following Act 67.
I guess I would, because we can't all get together outside of open records, I guess I would like to lean on you
Yeah,
to write that memo, and it could go through Jen. Now, correct me if I'm wrong, Jen, we write this up accordingly. Maybe you could use his memo as a cover letter to the resolution.
I'm not sure.
Okay.
I think unless we have something in writing that we can all review and agree on, you're not, I don't feel
Maybe we'll
like
let-
I don't think you'd be representing the full plan commission just because we don't have that. So if you feel that way, maybe you could present it as a resident or as a member of the planning commission.
And the resolution can stand, obviously, as,
What about, what if I circulated a draft of the memo to the town and get consensus?
It
Can-
has to be approved in a public meeting.
Yeah,
It has to
right.
be at the next planning commission meeting, which would then delay.
Well, I mean,
I can cite the reasons stated in my resolution because it was stated on the record.
right.
So it wouldn't necessarily have to be a separate memo because it was stated for the record.
It's basically that if we have to vote on something right now, let's do it, Joe. I mean, it's basically advising the town board that in order to be in accordance with Act 67, they can't overrule our decision unless they cite the facts and information that require.
Perhaps we could ask Attorney Mills to review that and provide guidance to the town.
Sure.
Yeah.
Or, to be honest, you could come to the town board meeting as a citizen
Yeah.
and put that
Yeah,
out.
that's a good idea.
Sure.
Yeah, I'm happy to do that.
Okay. So again, I think maybe, I would assume you have everything you need to write the resolution.
Once I
Based.
get copies of everyone's document.
Perfect. Okay. Is there any other business amongst commissioners tonight? Then I would take a motion to adjourn.
Motion to adjourn.
Do I have a second?
Second.
All those in favor? Aye. Opposed? We're adjourned.